Oo nga, kasi wala pa yung sa
on the determination of probable cause regarding the verified complaint for impeachment against Supreme Court Chief Justice Honorable Maria Lourdes P.A. Sereno, filed by Attorney Lorenzo G. Gadon and endorsed by 25 House members, is now called to order. May I hereby direct the COMSEC to call the roll of members of the Justice Committee.
Good morning, Your Honor. Roll call of members of the Committee on Justice. The Honorable Chairperson, Reynaldo Umali. The Honorable Senior Vice Chairperson, Vicente Veloso. The Honorable Vice Chairpersons, Doy Liachon, Henry Wominal, Arnulfo Fuentebella, Strike Revilla. The Honorable Regular Members of the Committee, Honorable Representatives Roy Loyola, Marlene Primicias Agabas, Jerry Treñas, Lucy Gomez, Rosemary Arenas, Bayani Fernando, Ruel Peter Gonzaga, Ramon Rocamora, Federico Sandoval II, Horacio Swansing Jr., Jericho Jonas Nograles, Lawrence Samuel Fortun, Munir Arbison, Arthur Yap, Divina Grace Yu, Noel Villanueva, Manuel Luis Lopez, Edward Vera Maceda, Jose Christopher Belmonte, Kakabag Au, Josephine Ramirez Sato, Xavier Jesus Romualdo, Juliet Marie Ferrer, Edwin Ong, Rodel Batocabe, Ron Salo, Sherwin Tugna, Carlos Roman Uybareta, Salvador Belaro Jr., Antonio Florendo, Macmod Mending Jr., Emeline Aglipay Villar, Michael Romero, Luisa Loen Cuaresma, Rodante Marcoleta, Robert Ace Barbers, Ferjanel Biron, Rodolfo Albano III, Romeo Acop, Gloria Macabagal Arroyo, Abigail Faye Feriol Pascual, Harleen Neal Labayan III, Manuel Monsur del Rosario III, Siriaco Calalang. The Honorable Ex-Officio Members, the Honorable Speaker Pantangol Alvarez, deputized with the deputization of the Honorable Johnny Pimentel, the Honorable Deputy Speakers Reneo Abu, Eric Singson, Fredinil Castro, Romero Kimbo, Mercedes Alvarez, Gwendolyn Garcia, Maylene Garcia Albano, Pia Cayetano, Sharon Garin, Linabel Ruth Villarica, who has deputized the Honorable Representative Ben-Hur Lopez Jr., Bay Sandra Sema, Ferdinand Hernandez, Frederick Abueg, Rolando Andaya Jr., the Honorable Majority Leader Rodolfo Fariñas, the Honorable Senior Deputy Majority Leader Juan Pablo Bondoc, the Honorable Deputy Majority Leaders Arthur Defensor Jr., Roger Mercado, Ann Hofer, Vincent Crisologo, Aurelio Gonzalez, Victoria Isabel Noel, Gerald Anthony Gullias, Arnel T., the Honorable Minority Leader Danilo Suarez, the Honorable Senior Deputy Minority Leader Jose Atienza Jr., the Honorable Deputy Minority Leaders Alfredo Garbin Jr., Eugene Michael De Vera, Anthony Bravo, Luis Jose Angel Campos Jr., and the Honorable Chairperson of the Committee on Accounts, the Honorable Elinita Milagros Ermita Buhain. Your Honor, the roll call shows that there are 29 regular and ex officio members present.
Thank you. The 29 members, both members and ex officio who are present in today's hearing. So, itong minutes next. We will defer the action on approval of the minutes of January 23 and 29, and so the chairman would now like to give his opening remarks. Good morning to the members of the committee and to the viewing public in today's hearing. The impeachment process enshrined in the Constitution was adopted by the framers to ensure that the highest officials of the land remain in check, accountable, and fit to remain and continue serving in office. The process before us is a faithful performance and upholding of the constitutional mandate of ensuring that officials holding key positions in Philippine government are with integrity, and those who are perverse in their ways are held accountable for their actions. Today marks another milestone in the impeachment process as the Committee on Justice for the first time conduct a full cycle in the initiation of impeachment proceedings, from filing and referral to determination of form and substance and grounds for impeachment, and now the determination and the vote on probable cause before completing the task of submitting the committee report and the articles of impeachment to plenary to impeach the Chief Justice. It will be recalled that in 2012, then Chief Justice Corona only went through half the process, that is, the Senate impeachment trial. No hearing was conducted before the Committee on Justice because 188 members of Congress, constituting more than a third of the House membership, directly filed the articles of impeachment in the Senate as an impeachment court. He was then perceived to have impeded the ability of the judiciary to function and dispense true justice to the people, and was convicted for failure to fully disclose some assets in his SALN. 6 years after, the focus is again on the judiciary, on its collegial nature, on its processes, including the non-filing and or failure to disclose some assets in her SALN, on the lifestyle of its key officials, and most importantly, on the fitness of the Chief Magistrate to continue to serve as head of the Supreme Court and the judicial branch of government. The Constitution dictates that at the minimum, all members of the judiciary must be persons of proven competence, integrity, probity, and independence. As public officers, they must at all times be accountable to the people, serve them with utmost responsibility, integrity, loyalty, and efficiency, act with patriotism and justice, and lead modest lives. Failure to live up to the foregoing standard impairs the ability of the Chief Justice to dispense justice. In fact, as the highest magistrate of the land, she must be held to a much higher, if not highest, standard. Today, Chief Justice Maria Lourdes Sereno faces an impeachment complaint filed by Attorney Larry Gadon, endorsed by 25 members of the House, putting into question her fitness to continue to serve as the head of the judiciary. There were 4 grounds raised and 27 different acts constituting the impeachable offense. After almost 5 months of probable cause hearings, totaling to 15 hearings, more than 30 persons, 10 of whom are current sitting judges of the Supreme Court, 1 retired Supreme Court Justice, 1 Justice of the Court of Appeals, 2 Sandigan Bayan Justices, 3 RTC judges, and other Supreme Court officials and employees, plus the Secretary of Justice. We now move on to determine whether indeed the probability that an impeachable act or acts had been committed by the Chief Justice. Notably, the Impeachment Committee consistently afforded Chief Justice Sereno the opportunity to participate in the probable cause hearings, to be able to defend herself and refute or controvert the charges against her. Unfortunately, she opted to simply monitor the proceedings and chose to air her side in another forum, the media, which unfortunately cannot be considered by this committee as part of the proceeding. Thus, members are enjoined to base their votes only on matters covered by and submitted to the committee. Despite the non-appearance of the respondent, the committee still allowed the participation of respondents' lawyers, who were allowed to ask questions through the committee members. As we evaluate the impeachment complaint heard before the committee, let us be mindful that the committee is constitutionally mandated to act as impeachment prosecutors. We cannot go to trial with a weak case nor without strong and convincing evidence. A heavy burden rests on the impeachment prosecutors in considering the testimonial and documentary evidence presented vis-a-vis the allegations in the complaint and the answers of both parties. At this juncture, to assist the members of this committee in performing their constitutional mandate, allow me to present to you the summary of findings as prepared by our legal team. We have prepared a PowerPoint presentation in matrix form to guide the members and the viewing public, showing each allegation against Respondent Sereno's answer and the facts that were established in the course of the probable cause hearings. For the guidance again of all members, the first impeachable ground raised is culpable violation of the Constitution, which refers to an act that is committed through a deliberate and wrongful breach of the Constitution. The chair submits that this ground begs answers to the following question or questions. Was there any constitutional provision violated? And second, was the breach of the Constitution deliberate and wrongful? 11 acts were ascribed by complainant under this ground, which, if I may just enumerate, one, she falsified the resolution of SC in AM number 12-11-9-SC on the reopening of Arcao 7. Second, she falsified the TRO of the SC in the case of Senior Citizens Party List versus COMELEC. Third, She falsified the resolution of the Supreme Court in AM number 16-08-04-SC in ordering the conduct of a motu proprio fact-finding investigation on the involvement of 4 incumbent judges in illegal drugs. She delayed action on the numerous petitions for retirement benefits of justices and judges and their surviving spouse or spouses. She manipulated and delayed the resolution of AM number 17-06-02-SC on the request of Secretary of Justice to transfer the Maute cases outside of Mindanao. She failed to truthfully disclose her SALN. She manipulated the shortlist to exclude Francis Hardelesa from the shortlist. 8. She manipulated the JBC shortlist through clustering of nominees for the 6 vacancies in the Sandigan Bayan. She failed to heed the pronouncement of the Supreme Court in the case of Aguinaldo versus Aquino, declaring the clustering of nominees as unconstitutional, and continued to cluster the shortlist for the 2 vacancies left by SC Justice Bienvenido Reyes and Jose Mendoza. 10. She lied and made it appear that several justices requested that the SC do away with the voting of the recommendees to the Supreme Court. 11. She manipulated the JBC by influencing its 4 regular members. The second ground raised in the complaint is corruption, and it covers an act of an official who unlawfully and wrongfully uses his station or character to procure some benefit for himself or for another person contrary to duty and rights of others. Under this ground, the committee needs to determine whether or not the Chief Justice committed acts of corruption as defined under existing laws, including but not limited to Republic Act 3019. The 3 acts that constitute the impeachable ground of corruption as alleged in the complaint are as follows. That the Chief Justice committed corruption when she used public funds to finance her extravagant and lavish lifestyle by ordering the purchase of a brand new, luxurious 2017 Toyota Land Cruiser as her personal vehicle amounting to more than 5 million pesos. That she committed corruption by staying in opulent hotels when attending conferences in the Philippines and abroad and flying on business or first class together with her staff and security. That she unnecessarily brought a huge entourage of lawyers in her supposed foreign official trips. The third ground for impeachment raised in the complaint is other high crimes, which refer to those offenses like treason and bribery are indictable offenses and are of such enormous gravity that they strike at the very life or orderly working of government. Under this ground, there were 4 acts attributed to Chief Justice Sereno of having violated this particular ground. One is by ordering the Muntinlupa judges not to issue warrants of arrest against Senator Laila M. De Lima, by meeting the presiding justice and associate justice of the Court of Appeals and instructing them not to comply with the processes of the House of Representatives and to immediately raise the issue before the Supreme Court regarding the amnesiac 6 provincial officials in Ilocos Norte. Third is the chief failed to report her extortionate attorney's fees and paid the appropriate taxes therefore. That she embellished her personal data sheet in her application for the judiciary to overstate her credentials. The fourth impeachable ground raised refers to betrayal of public trust. And this refers to all other acts which are not punishable by statutes as penal offenses, but nonetheless render the officer unfit to continue in office. It includes betrayal of public interest, inexcusable negligence of duty, tyrannical abuse of power, breach of official duty by malfeasance or misfeasance, cronyism, favoritism, etc., to the prejudice of public interest and which tend to bring the office into disrepute. These definitions were called from the discussions and deliberations in the Constitutional Commission, which drafted the 1987 Constitution. As we near the end of this impeachment proceeding, let me assure everyone that the committee have faithfully performed its constitutional mandate to exclusively initiate all cases of impeachment as provided under Section 3, Article 11 of the Constitution. Sooner than later, we will embark on a new chapter in impeachment proceeding as prosecutors before the Senate as an impeachment court. Throughout the probable cause hearings, this committee have gathered sufficient evidence to provide us with the ammunition to prosecute this case towards victory. The remedy of impeachment was given to us by our Constitution to ease the nation of undeserving officials. The power is now in our hands. Such is inherent in us since this is a government of the people, by the people, and for the people, and we members are the representatives of these people. Be it remembered that when the High Court errs, this error becomes part of the law of the land. Therefore, justices, particularly of the Supreme Court, must be the embodiment of justice and fairness, and their reputations ought to be free from even the mere appearance of partiality and moral corruption. Thank you, and may we be guided by our moral conscience and conviction in appreciating the findings of this committee as we later on cast our respective votes on whether the Chief Justice whether there is probable cause to impeach the Chief Justice. Maraming salamat po at magandang umaga po sa ating lahat. So at this point in time, may I know if COMSEC, if the 25 endorsers are here or if any of the representatives are here, because at this juncture, we will give them time to make their plea or appeal or manifestation to this committee, having endorsed this complaint of Attorney Larry Gadon. We now recognize Congressman Dong Gonzales.
Thank you, Mr. Chairman. I'm one of the 25 endorsers, Mr. Chairman. Our Majority Leader, my colleagues, good morning. To my fellow representatives and members of this committee, today we will be voting on the existence of probable cause of the impeachment complaint filed against Chief Justice Maria Lourdes Sereno. In the hearings this past month, the entire nation witnessed the proceedings unfold before this committee and listened to the testimonies of all the witnesses, which even included justices of the Supreme Court themselves. In the extensive clarificatory hearings conducted, this committee was able to unveil the misdeeds committed by Chief Justice Sereno that were not even alleged in the complaint, like her failure to truthfully declare her properties in her statement of asset, liabilities, and net worth, her non-filing of the SALNs during the years she was a professor at the University of the Philippines, her tax misdeclarations, unauthorized expenses, and manipulative maneuverings in the JBC and Supreme Court resolutions that were not made to pass through en banc. My dear colleagues, among others, as we dug deeper into it, we have unleashed facts that even caused the Office of the Solicitor General to file a quo warranto case against Chief Justice Sereno. Were it not for the impeachment proceedings before us, we would not be able to discover all of these misdeeds and violations of law. With this, and in behalf of my colleagues, my fellow 25 endorsers who endorsed this impeachment complaint, I urge you now to vote in favor of the truth. Let us perform our constitutional mandate of ensuring that the Chief Magistrate remains accountable and fit to lead the third branch of government, the judiciary, for the benefit of the people whom we ought to serve. I enjoin to vote in favor of the determination of probable cause. That's all, Mr. Chairman. Good morning to all of you.
Thank you, Congressman Gonzales. And just for the benefit of everyone, and of course, for the record, let me just read to you the names of the 24 other endorsers of this impeachment complaint. Of course, we have Congress Deputy Speaker Gwen Garcia, who is here and is a member of this committee. Honorable Edgar Mary S. Sarmiento. Honorable Anthony M. Bravo is also here and is a member. Honorable Arnel T. Honorable Rodolfo T. Albano. Honorable Francisco Matugas II. Honorable Federico S. Sandoval II, Honorable Joel Mayo Z. Almario, Honorable Romeo A. Acop, who is here and is a member, Honorable Vincent Crisologo, Honorable Maylene Garcia Albano, Honorable Pedro Acharon Jr., Honorable Xavier Jesus Di Romualdo, who is here, Honorable Gil Acosta, Honorable Ann K. Hopper, who is here, Honorable Winnie Castello, Honorable Ferdinand L. Hernandez, who is here, Honorable Jericho Nograles, Honorable John Marvin Nieto, Honorable Robert Ace Barbers, Honorable Frederick F. Abueg, Honorable Roger Mercado, who is here, Honorable Jennifer Austria Barsaga, and Honorable Lorna Bautista Bandigan. So, what is the pleasure of Honorable Bravo?
Thank you, Mr. Chairman. Good morning. Can I have also my manifestation? Manifestation, Mr. Chairman.
Please proceed.
Thank you, Mr. Chairman. Good morning to our distinguished colleague, our Majority Leader. Hindi po madali ang maging bahagi ng dahilan kung bakit mawawala ng trabaho ay isang tao. Lalo na kung ang katotohanan ay ito ay isang pagpapatalsik sa pwesto ng isang napakataas na opisyal ng pamahalaan. Ginagalang po natin ang opisina ng punong maestrado. Pero sa aking palagay ay dapat kung sino man ang nakaupo rito ay mananatiling kagalang-galang din mula sa simula hanggang sa katapusan ng kanyang paninilbihan. I'm not a lawyer, Mr. Chairman, but I'm a Filipino who cares about what is just and right. And I am a public servant, sworn to my duty to protect and defend the people from what is wrong. Hahayaan ko na po ang aking mga kasama na abogado rito sa Kongreso na ilatag ang lahat ng legal basis para sa impeachment ng ating Chief Justice. Pero hindi ko po pwedeng hayaan ang aking tungkulin na di makilahok sa napakalahagang prosesong ito. My questions are simple, Mr. Chairman. First, can the people still trust the Chief Justice after everything that has been revealed in the public hearings? Second, can the Supreme Court still serve as a collegiate body that is the last bastion of truth, justice, and democracy, knowing that it is divided beyond repair, not just legally, but also ironically, politically? Third, can its ruling still be accepted by our people as competent, credible, and consistent, given that dirty linens has been washed in public for all to see, hear, and feel? My Chairman, my colleagues in the House of Representatives, my answer to all the above questions is a resounding no. So I encourage each member of this honorable body to vote in favor to proceed with impeachment, that there is indeed a probable cause to impeach the Chief Justice. This will not solve all the problems that we have discovered, but this will be a good start. And we have to start immediately for the sake of the present and the future. Thank you, Mr. Chairman.
Thank you, Honorable Bravo. We now recognize Congresswoman Kakabagaw. Di ba? Sabi mo, hindi? Kit? Wala.
I am not an endorser, sir.
Hindi.
I did not raise my hand, sir.
Kasi binulong sa akin ng aking COMSEC na you wanted to make a manifestation. Any other manifestation before we proceed? Yes, Majority Leader.
Please allow me to give a summation of what happened here in the past 18 hearings. See, I was also the one who gave the summation in the trial of the Chief Justice, of the late Chief Justice Corona. So what we have here now is a tale of two impeachment cases of two Chief Justices. Magkasunod pa po sila. In December 12 of 2011, this House impeached the Chief Justice, a sitting Chief Justice of the Supreme Court, Renato Corona, without giving him the opportunity to be heard. No hearing was conducted. In fact, how was the impeachment complaint done or prepared? We were invited to Andayo Hall one afternoon, and everybody was lining up to sign the impeachment complaint against Renato Corona. Ilang pages? 188 members signed, 55 pages, yung complaint against the Chief Justice. I was there. I was a deputy majority leader. I was the senior vice chair of the committee, this committee. I was on my first term on that second return in the Congress, but I did not sign. Why? Like Pido Garbin here, Alfredo Garbin, who just reminded me now when I asked him, and maybe he told me, sabi mo sa akin noon, Manong pipirma ka nito, itong ganitong klaseng complaint para ka naman hindi abogado. Because, and yet, even if I did not sign, when the House elected its 11 prosecutors, I was made a prosecutor. Sabi ko, hindi na ako dapat dyan dahil hindi nga ako complainant, hindi nga ako pumirma sa complaint. But the speaker then, Feliciano Belmonte, prevailed upon me, kailangan ka namin dyan. So, reluctantly, I allowed myself, and I was the only prosecutor who was not a complainant. Why did I not sign? Minadali. In fact, when I was asked during the trial by no less than Judge Senator Jingo Estrada, why did you not sign the impeachment complaint? My answer was, in levity, may kasamang biro, mabagal po kasi akong bumasa. Ang bilis po Yung iba, magagaling. Yung mga kasama ko, mukhang mga speed reader lahat. Tinignan lang, pumirma na sila. Ako po, mabagal po ako bumasa talaga. So, binasa ko po mabuti. Hindi pa ako tapos. Tapos na lahat sila. Parang pass your paper, finish or not, ready or not, parang ganun yung nangyari. Or, dahil na-breach na naman, umabot na naman yung kailangan na numero na 1/3, hindi na lang ako pumirma. At dahil medyo masama rin ang pagkagawa. Yan ang sinabi ko on national TV during the hearing. Na-impeach si Chief Justice Corona by the House without any hearing. Maski isang beses man lang. Hindi man lang siya pinagpaliwanag. Chief Justice Corona, may complaint dito. Ano masasabi mo sa complaint na ito? Hindi po. Yung Congress, yung House of Representatives, dinala kaagad. Yung complaint o ihinabla kaagad doon na hindi man lang binigyan ng pagkakataon si Chief Justice Corona para makapagsalita. Yun po ang nangyari doon. 8 po ang articles of impeachment na ginawa. Pagdating po doon, para po kaming nangangapa-ngapa doon. Napagsasabihan, napagtatawanan, hanggang inalis namin yung ibang articles of impeachment. At yan ang payo ko sa atin ngayon dito. Pag-aralan mabuti yung committee report natin. When we prepare the articles of impeachment, let us pick a few only. Hindi na natin, kasi when we go to trial, if ever we go to trial, we have to prove each article of impeachment. Matagal po yan. So, parang very good. Kasama ko rin si chairman noon. He was one of the, in fact, leading prosecutors. So, piliin na lang natin siguro yung iba doon. Yung iba, kung pangparami lang, huwag na natin isama. Now, we go to the impeachment of the present Chief Justice. Yan po. Nakalabing 8 hearing na po tayo dito dahil sa masipag na chairman natin at sa inyong lahat. Minsan, umaabot pa ng hating gabi, maghapon. And the Chief Justice was given every opportunity to present her side. Pero she chose not to. In fact, baliktad ito Yung respondente mismo nagsasabi, dalhin nyo na. File nyo na sa Senado. Mas marunong ka pa sa amin Respondente ka dito. Do not tell us when to file it. Minabatili niya, the power to impeach includes the power when to impeach. Pinag-aaralan po namin mabuti yan para hindi po mangyari uli yung nangyari sa amin noon nung may Chief Justice. Kaya, as Majority Leader, I wish to commend on behalf of the Speaker, the Committee on Justice sa perseverance. Kasi kinakantyawan na nga tayo Kinakantyawan tayo mismo yung noong respondente. Lalo na yung kanyang mga tagapagsalita. Oy, tigil nyo na, file nyo na yan kung may kaso kayo. Saan ka naman nakakita ng gano'n na hindi man nila respetuhin, nangahamon, minamaliit pa yung ginagawa dito. May problema, hindi ka naman Chief Justice dito, respondente ka dito Sumagot ka. Kung ayaw mo, edi pagbigyan mo kami, gawin namin yung trabaho namin. Huwag niyo kaming tantyawan na, oy, bakit niyo pinapatagal yan? Ang rules po namin, 60 session days nga po ang binibigay dito sa committee na ito. Nakailang session days tayo? Wala pa. Hanggang Mayo 15 pa ho sana ito. Maski para malaman po niyo yung proseso, pagkatapos dito, gagawin yung committee report, pagbubutuhan po yon, darating po sa akin sa Committee on Rules. Yung Committee on Rules has 10 days, 10 session days to also include it in the calendar of business. 6 na araw lang po ang session days na natitira na ngayon. Pag lagay po naman yan sa plenaryo has 60 session days to dispose that committee report. So, baski aabot pa ng October 31 po ito. Huwag po kayo nagmamadali dahil hindi lang po ito ginagawa namin. Marami po kaming ginagawa. At majority leader, as the chairman of the Committee on Rules, i-schedule ko yan. Dahil darating na yung budget ng presidente and everything. Total, naka-leave naman na yata siya. So, huwag siya magmadali. Mag-enjoy muna siya habang naka-leave siya. At ayan po, pag-aaralan po namin. Now, yan po ang aking, like I said, on behalf of the Speaker, is a commendation to the chairman, the way we handled this hearing, and I also appeal that when we come up with the committee report, medyo yung articles of impeachment, medyo gawin natin maganda para mas magandang butuhan natin yan sa plenaryo. Thank you, Mr. Chairman, and thank you, my dear colleagues.
Thank you, Majority Leader, for that manifestation. I think that really showed the difference between this complaint, impeachment process that we went through. Sabi ko nga kanina, yung nangyari po kay Chief Justice, former Chief Justice Corona, kalahati lang po yun. Yun po yung Senate trial. Walang ganito. Ngayon naman, bubuin po natin because of this impeachment committee hearings that we conducted. So meron na po tayong kompletong picture and idea of what the impeachment process covers, no? So maganda po ito, and we have clarified many of the things that we ought to cover and define in the impeachment process. So at this juncture, before I call and I direct the ano pa muna, may PowerPoint presentation yung ano.
Mr. Chairman,
okay, what is the pleasure of Congressman Bondok?
Mr. Chairman, kanina po nagsalita ang isang kasamahan natin, si Congressman Anthony Bravo. Nabanggit po niya at napakahalaga ng kanya sinabi. Tatagalogin ko po, mapagkakatiwalaan pa po ba ng sambayanan ang punong mahistrado sa kabila ng mga alegasyon na nabuksan po sa public trial, sabi po niya. Ngayon po, Mr. Chairman, gusto ko lang po para mabuo ang pagkaintindi ng publiko. Meron po kasi tayong naging executive session nung nakaraan, kung saan po tinalakay po natin ang tungkol sa psychological exam ng punong mahistrado. Ngayon po, ayon po sa ating mga rules na nandito po, pwede po tayong mag-executive session kung ang national security po ang nakataya sa usapin. Ngayon po, sa aking pag-aaral, meron naman po kasi akong hawak dito ngayon na nakapagbigay ng impormasyon po sa atin, isa pong artikulo sa Manila Times. Sulat po ng isang Jomar Canlas ang date po ng article ay November 27, 2017. Ang pamagat po nito ay 2 psychiatrists who failed Sereno named. Ngayon po ayon sa aking pagtalakay dito sa article pong ito sa Manila Times, nakita ko po dito na ito po ay alam na ng publiko dahil lumabas na po sa dyaryo. Ang usapin dito tungkol sa psychological exam ng punong mahistrado. At sabi nga ni Congressman pong Tony Bravo, mapagkakatiwalaan pa po ba natin ang punang mahistrado kabila ng impormasyon na nailathala sa public trial? Ito pong usapin na ito ay hindi po alam ng publiko dahil ginawa sa executive session at kung mamarapatin po ng committee, minumungkahi ko po, hindi naman po ito nakakaapekto sa national security at dapat malaman ng lahat ng miyembro bago sila bumoto, Mr. Chairman. So total, nandito naman po sa article at kung kaya po ng ating staff, pwede po ba ang importanteng articles na ito ay flash nila para makita sa publiko. Itong Manila Times article dated November 27 na sulat po ni Jomar Canlas. Ayan po, pinaprepare ko po. Ang nakasaad po dito kasi, ayon sa resulta ng 11-page psychiatric report ng psychiatrists Reyes and Ranoy, kung saan po ang scale ay 1 to 5. Ang grade po, 1, 2, 3, 4, 5. Ang 5 o grade na 5 ang pinakamababa. Si Chief Justice Sereno, ayon sa article po na ito, ay nakakuha ng rating na 4. Malapit po siya sa bagsak na 5. Hindi naman po nakakaapekto sa national security. Gusto ko po sana ma-share sa mga miyembro kung ano yung natalakay natin sa executive session. At ito naman po kasi ay kasama na sa article na ito. Kaya ang motion ko, Mr. Chairman, sana i-declassify yung discussion ng executive session, pagbotohan po ng mga miyembro na nandun, kung ito ay humahawig naman sa article na alam na ng publiko, nang sa ganun, sabi nga ni Congressman Bravo, mapagkakatiwalaan pa ba ang punong mahistrado sa kabila ng impormasyon na nailathala sa public hearing? Dapat po marinig ng publiko at ng mga kasama nito. So yun po ang motion ko, Mr. Chairman, to please declassify yung pinag-usapan sa executive session on the grounds na it does not affect national security at kasama naman po ito sa article na ng Manila Times, alam na ng publiko. So move, Mr. Chair.
Second. I object, Mr. Chair.
Okay, please state your objection.
Una po, babalikan ko lang po yung matagal na nating pinag-uusapan. Nagtatalakay na naman po tayo ngayon ng ebidensya na base sa isang news article. Akala ko huban nalampasan na natin yung stage na yan. In fact, yung pride ng committee na ito ay mahabang committee hearings to persevere at talagang zealously i-present ang iba't ibang mga testimonya. Kaya kung magbabase na naman po tayo sa article, tingin ko po hindi na po siya maayos na magiging batayan ng mga members at na mag-decide po para sa issue. Kaya po in-object ko kung yun po ang magiging proseso. At pangalawa, doon sa executive session, natalakay po ng mga miyembro na dapat makarinig doon sa talakayan. At kung pupunta po tayo sa pag-discuss ng sino po ang nag-testify, ano pang ibig sabihin ng mga result, di okay lang naman pong talakayin natin. Pero kung ang tanong po ay mag-present lang po ba tayo ng news article at therefore pagkatapos na okay na po tayo ay nag-object po ako, Mr. Chair.
Mr. Chairman.
Kung Kit, para makompleto lang yung objection din yan, Kit?
Yes, Mr. Chair, objection
Okay,
din po.
please.
I was there during the executive session and the subsequent hearing after, Mr. Chair. I think I would just like to remind the Honorable Deputy Majority Leader na yung mga pinag-usapan natin after, including after that executive session and the hearing after, natalakay na po natin yan. In fact, all the members present, if the others who were there with me, including the chairman, pinag-usapan na ho natin itong mga bagay-bagay na to and they were entered into the records. In fact, yung mga points na rineraise ng Deputy Majority Leader ay yung points mismo na na-raise din ng chairman, kaya ho napasok sa testimony yung sinasabi nung si Dr. Tria ba yun? Yung psychiatrist. So, therefore, Mr. Chair, ang tingin ko po, wala na hong bagong mapag-uusapan dito kasi napag-usapan na po natin. Yun lang po, Mr. Chair.
Yung motion is to declassify.
Yes, Mr. Chair.
No? So, kasi classified yon, confidential yon, unless declassified.
Exactly,
So,
Mr. Chair. I don't see any other value for declassifying that
okay.
data.
Congressman Galvin.
Thank you, Mr. Chair. What is being moved to declassify is the result of the psychiatric examination, not the one being shown in the presentation that was just an article in a newspaper. Now, as a matter of procedure...
Premise lang yan. Parang premise lang yata ni
Yes.
Kong Rimpi.
Yes. And as a matter of procedure, Mr. Chair, testimonies and evidence during the executive session can be made of public upon approval of majority vote of all the members present today.
Yeah, that is why there is a motion duly seconded, but there is an objection. And yun na nga, let me just clarify, no? Pagkatapos po nito, pag na-impeach na po after we vote upon it sa plenary, kailangan po natin ng ebidensya pag-akyat po natin sa korte, sa Senate Impeachment Court. And so, if this particular document will remain to be classified, hindi po natin pwedeng gamitin yan. So, yun yung dilemma natin ngayon, and I guess that is the reason for Kong Rimpi to move to declassify this because we may, or ako, para sa akin, sa tingin ko, baka kailangan natin gamitin ito in proving our case before the Senate Impeachment Court. So, yun po yung rason na yun. Siguro, dadagdagan pa ni Rimpi before we recognize Kong Kit Belmonte.
Opo, Mr. Chair. Wag po sana magkamali ang kasamahan natin. Ang ginagalang ko po si Congresswoman Bagaw at si Congressman Belmonte, na akala nila po ay sa pamamagitan ng declassification, dinidiin po natin ang punong mahistrado. Hindi po. Binibigyan po natin siya ng pagkakataon para ipaliwanag ang artikulo pong ito, this article, na lumalapastangan po sa kanya, na nagsasabi na bumagsak siya sa psychological test. Kailangan po malaman ng publiko at ito ang pagkakataon para masabi ng punong maestrado, hindi po totoo yung article na yan. Inaantay nga po namin siya na dumating at sabing, hindi po totoo yan. Pero ito po hindi natalakay. Hindi po natin alam sa ngayon, hindi pa alam ng publiko kung ano ang naging usapin. Sabi nga ni Kong Pido, at gusto ko po sana ayusin ng konti, ang sinabi niya, yung resulta po ng psychological exam, ang gusto nating i-declassify. Hindi lang po yun. Kung hindi yung buong hearing, kung saan maaring doon lumabas na wala pong problemang psychological ang punong mahistrado. Maaring lumabas doon na karapat dapat siya at ayon sa mga eksperto, wala siyang tama po sa utak. So, yun po ang pagkakataon na pabulaanan po ang article na ito kung saan po masyadong nakadiin naman ng Chief Justice at di siya nabibigyan ng pagkakataon magpaliwanag. Hindi po natin alam, di pa alam ng publiko kung ano ang laman ng hearing na yon, kung saan maaring mapatunayan na karapat dapat siya psychologically. O rin din, maaring hindi. Pero kailangan malaman ng publiko at ng committee ito. So, both sides ito, Mr. Chair. Ang katotohanan lang naman po ang ating pinalalabas. Wala pong dapat ikatakot ang mga kasamahan natin na maaring sa nakaraang impeachments ay pumirma na rin sa mga impeachment tulad ng naipaliwanag ng ating majority leader na hindi na pagbigyan ng pagkakataon yung respondent. Yun lang naman po, Mr. Chair. Salamat po.
Thank you for that, Kong Rimpi. We recognize Kong Kit and then Kong Rodel Batoabe.
Thank you, Mr. Chair. I'd like to correct the misimpression siguro created earlier by the arguments. Simple lang po yung point ko, Mr. Chair. Ang purpose ng hearing na to ay determination ng probable cause. Hindi po para pag-usapan natin kung kailan natin may introduce yung mga evidence na yon. Ang pananaw ko po, sufficient po yung talakayan natin under the executive session and the subsequent hearings after, the subsequent session after, kung saan pwede na nating i-base yung reasonable judge determination natin kung may probable cause on that issue. Tingin ko wala pong further value yung erase po natin yan kasi parang binubuksan ho uli natin. Kung bubuksan po natin dyan, madami hong mga circumstances or mga, how do I say this? Mga resource persons na pwede pa ho natin buksan kasi feeling ng isang member or another na, teka, kulang pa, dapat may nahabol pa po tayo. Feeling ko, ang position ko lang po, dahil nandito na ho tayo sa determination ng vote, sufficient na po yung napag-usapan po natin. Yun lang po, Mr. Chair.
Anyway, that is your opinion na sinasabi mo nga. The purpose of this is to determine probable cause and define what articles will fall within the articles of impeachment, kung ano po yung isasama natin. And so, kasama na rin po doon yung pagdetermine ng evidence. So, let me just correct that misimpression that may have been created by that, na magbobotohan lang tayo. This is a process, no? Kasama po ito, kasama na rin yung pagbuo ng articles of impeachment at pagdetermina kung anong ebidensya ang gagamitin natin doon sa mga papasok po doon sa articles of impeachment. Kaya ang hinihingi natin, hindi na natin kailangang pag-usapan. Ang gagawin lang po natin, i-declassify po natin para magamit po natin probably as part of evidence. Tapos na po yung probable cause hearing, terminated na po yon as of last week, and we will no longer open this proceeding to another probable cause hearing to discuss that. Anyway, meron tayong voting sa plenary at the proper time, and this is where issues on the matter can be raised. Pero para po magawa yung trabaho na buuin yung articles of impeachment, marahil kakailanganin po nating i-declassify itong information na ito. So, we now recognize si Kong Rodel and then Kong Gonzaga.
Salamat, Mr. Chairman. Sa ganang akin po, ang impeachment proceeding, kaya lang tinatawag nating sui generis, isa po itong unique na proceedings in the sense na hindi po tayo talaga ang umuhusga, kundi ang taong bayan. Kaya binigay sa atin ang paghuhusga o pagpapaalis ng isang mataas na opisyal dahil po tayo ay kinatawan ng taong bayan. Ngayon, dapat lahat na ginagawa natin ay wala dapat tayong itago sa taong bayan. Dapat isiwalat natin, ipakita natin kung ano ang mga pinag-uusapan natin. Walang matatago sa taong bayan dahil ang ultimo na maghuhusga dito ay hindi po tayo. Kasi kinatawan lang po tayo ng taong bayan. Ang maghuhusga ay ang taong bayan. This is the philosophy behind the impeachment. Eventually, it is the people themselves who will judge an impeachable official. So, batayo sa ebidensya, titingnan ng taong bayan kung naniniwala sila o hindi. At pag sinabi po ng taong bayan, ay, wala na kaming tiwala, lumayas na yan. Siyempre, makikinig po ang ating mga kinatawan. Ganun lang po, Mr. Chairman.
Mr. Chair.
Kong Gonzaga and then Kong Bagaw and then Kong Kit.
Thank you, Mr.
Alright.
Chair. The only issue raised by Kong Bundok is whether or not we can declassify the results of the proceedings during the executive session that happened last week. Now, if there is an objection, it has a legal basis. Now, what would be the law that could prevent us from declassifying the proceedings during the executive session? As of this moment, there is none. Wala pong batas na pwedeng mag-prevent sa atin to declassify all those things. So, with this regard, Ang sabi kanina ni Kong Bundok, there are only two reasons preventing us from declassifying. One, if it is against the national interest and against public and national security and public interest. So this declassification does not involve national security. It does not involve public against public interest. So the objection stands. The objection has no basis at all. So therefore, if we rule on this, we must stand on legal basis. Thank you po.
Mr. Chair.
Congresswoman Bagao.
Mr. Chair, wala naman po tayong pinagtatalunan. And with the clarification that the Chair already made earlier, that the intention was merely to declassify the document that was presented in the executive session. Hindi po yan yung classification. So, yung declassification ang objective, wala po tayong pinagtatalunan dyan. At in fact, ang sinasabi ko nga ay nag-umpisa lang po ako doon sa introduction that we will be talking about a news article. At pangalawa, nagkaroon na naman ng public hearing after ng executive session kung saan present si Dr. Tria na tungkol doon sa psychological test na kahit hindi siya ang nag-examine kay Chief Justice. So, with the clarification of the Chair, I will withdraw my objection on the motion to declassify.
Thank you for that. Kongkit, are you also withdrawing your motion?
Likewise, Mr. Chair, with the clarification of the Chair, we withdraw likewise withdraw my objection.
So, since the matter is no longer being objected to, then the Chair hereby declares that
If I may just clarify, the motion is to declassify all of what had been discussed in that executive session. We are not only referring to a document, we are referring to the executive session that we had, which took all of 3 hours, and it covered a range of matters. Just for clarification, Mr. Chair.
Okay, so there being no objection to the motion to declassify the psychiatric evaluation report and all matters covered by the executive session conducted last week, the motion is carried and the information is now declassified. So now the Chair would like to know if meron na ba silang summary of findings? Meron kayo? Wala? Ba't hindi?
Mr. Chair, can I raise a parliamentary question?
Please.
May this representation know the procedure or the manner of voting that we will be conducting today?
Yeah, that's why I'm leading to that, no? Because the staff, the COMSEC committee secretariat had already prepared a summary of findings presenting the foregrounds and then the allegation, the answer, and that of the facts established in the course of the 15 probable cause hearings. The Chair would like to know the pleasure of the members, whether you want to go through this one by one or just we will submit this for the body to vote upon probable cause on the basis of this summary of findings. Anyway, we have been here religiously attending the hearings. I think you have sufficient basis to already make your own conclusions and decisions in voting for either probable cause or not to vote negatively thereon. So, what is the pleasure of the body?
Mr. Chair.
Please, sige.
To explain my query earlier, will we be given the opportunity to explain our vote?
Not at this time. That will happen when we go to plenary. But at this time, we will just vote on whether this committee finds probable cause, and this is the working document to base it thereon. Of course, plus all your participation during the various committee hearings, the probable cause hearings conducted I think, for about 15 times.
Thank you, Mr. Chair. So I would just like to manifest that this representation with Kong Kit Del Monte filed a manifestation to also explain our position on the issues and allegations that were raised. So we filed a memorandum to this committee, Mr. Chair. Thank you.
Okay, so this has been filed already, and so the committee takes note of this memorandum filed by Congressman Keith Belmonte and Congresswoman Kakabagao, and we will take note of this in the course of memorandum on probable cause hearings filed. We will take note of this and consider this when we again submit the report next week, together with the articles of impeachment, depending on the votes or on the decision of this committee that we will get today. So, so what is the pleasure of Kong Leachon?
Mr. Chair, yes. Good morning. So with our majority leader and our dear colleagues, well, it's my humble opinion that considering that we have deliberated all of the charges, and in fact, they've been supported with several testimonies coming from all witnesses, and we have been here for quite some time already. I think it would be just a repetition of what we have already established. After all, before going here, each member I know has in his mind and heart his own decision and conviction on how to vote on the determination of the probable cause. And considering further that, after all, if whatever will be the vote of each member, and as a totality, the whatever decision will still be definitely be passed upon before the plenary. And there again, it will be subject to the scrutiny of each member of the House. So I therefore move, Mr. Chair, that we dispense with the presentation of the findings, and may we therefore go to the meat of the meeting today, or the hearing today, which is for the determination of the probable cause. Thank you, Mr. Chair.
Mr. Chairman. The motion, Mr. Chair.
So,
Mr. Chairman.
it has been moved and seconded.
Mr. Chairman.
What is the pleasure of...
Just an observation. There are many charges against the Chief Justice. And from my conversations with different members, there are some charges which they seem to agree with each other that it will be dropped. So I think I would suggest that we go one by one, we state one, and then we vote for, and then so that we will know what charges we will make in the impeachment, and what not to include in the impeachment. I would suggest
Point of order, Mr. Chair.
Please,
Let me
what's the
just
point
read
of
the
order?
rules on Section 8, which governs the rules of procedure in impeachment proceeding. It says, if the committee finds by a vote of the majority of all its members that the probable cause exists on the basis of the evidence adduced before the committee, it shall submit with its report a resolution setting forth the articles of impeachment. Otherwise, the complaint shall be dismissed subject to Section 11 of these rules. It presupposes, Your Honor, that the rules that we will vote in totality, not individual rules.
Thank you for that that clarification, and that invokes the rule that we must be guided on. So anyway, there is a motion duly seconded. There is a manifestation.
Mr. Chairman, I will just withdraw.
Thank you for that.
What they read in the rules of business, I will just withdraw my
Okay,
suggestion.
so is there? Do I hear any objection? There being none, the committee is now hindi, pero may motion. The motion to dispense with the presentation of the summary of findings is granted. So the committee will now proceed to take a vote on whether or not the committee finds probable cause against the Chief Justice to impeach the Chief Justice. So what is the pleasure of the body?
Mr. Chair, may I, yes.
Kong de Vera?
Yes, Mr. Chair, Majority Leader, good morning. I respectfully move to vote on the determination of probable cause of the verified complaint for impeachment against Supreme Court Chief Justice Sereno, Your Honors, filed by Attorney Lorenzo G. Gadon and endorsed by the 25 House members, Your Honors. So moved, Mr. Chair.
May I amend, Mr. Chairman? We shall move to find probable cause.
Move to find probable cause. So
Yes.
it has been moved and seconded so that we can appropriately count the number of votes in favor of impeaching or finding probable cause to impeach the Chief Justice. May I request the members in favor of finding probable cause to please rise. Of course, those voting should only be members and or ex officio members or deputized members. Ilan? Thank you, ladies and gentlemen. Please take your seats. Those who are against the finding of probable cause to impeach the Chief Justice, please rise. With a vote of 37 against, 2 in favor, and 2 against, this committee finds probable cause to impeach the Chief Justice.
Mr. Chairman,
yes, Majority
pursuant
Leader.
to our rules, in order that we will have a very thorough committee report, I move that all the vice chairpersons of the committee will be constituted as a small body to draft the committee report.
The articles of impeachment.
Committee report.
Inclusive.
Together, including the articles of impeachment.
It has been moved and seconded. There being no objection thereto, the vice chairs of all the vice chairs of of this impeachment committee and the Justice Committee are hereby constituted as the small body to write the report, including the articles of impeachment. Do I hear?
I move.
Yes.
When? May we now set, Mr. Chairman, the date of our next meeting with the aim in view of the submission of the draft committee report and articles of impeachment, and that will be on March.
Mr. Chairman?
There's a unfinished motion.
I think the motion was already rolled to be approved.
No,
As Vice Chair,
I'm
asking
moving the date of our next meeting when the report will be submitted.
probably as a preliminary to that, the Honorable Majority Floor Leader, as one of the Vice Chairs, I'm asking the Chair whether or not we would be given a timeline or give us a timeline for us to submit the committee report. Okay.
To submit to the rules.
Dito, sa committee. Dito, i-approve natin.
Boss, naka-on siya. Patayin natin.
We,
May we suspend the meeting for a few minutes, Mr. Chairman? I move to suspend the... Suspend muna tayo.
hearing is suspended for a few minutes.
Mr. Chairman, may I proceed with my suspended motion?
Please, Majority Leader.
I move, Mr. Chairman, that the committee that we constituted be given until Wednesday, March 14, to submit its report before this same body and for this body to vote on the committee report on that day. This shall serve as notice to members.
There being a motion duly seconded, the small working body is hereby directed to complete its task of preparing the report, including the articles of impeachment, and present the same to this committee on 14 March, which is a Wednesday, at 9:30 a.m., where we will resume hearing again to vote upon the matter. So,
Mr. Chair?
Session hearing is
Mr.
suspended.
Chair, before we suspend, Mr. Chair, at the behest of the Secretariat, gusto po nilang i-correct yung voting. Ang tama po palang bilang, 38-4, 2 against. 38-4, 2 in favor. 38 in favor, 2 against.
So, just for the record, the vote earlier made was 38-4, a finding of probable cause, and 2 against. Let the records be corrected. And hearing is hereby suspended until 14 March 2018 at 9:30 in the morning.